The parties did not go on the record. They came to an agreement. Consequently, this court has never taken a single word of testimony about whether this minor child should be vaccinated. This court has never made a finding that the minor child should be vaccinated based on any evidence or exhibits. The court was not asked to because the parties agreed with their attorneys present in the November order. Since then, 10 months have gone by, and mother has failed to comply with the order that she agreed to. No appeal was filed, no motion for reconsideration was filed, no stay was requested. The court has contempt powers specifically for this reason, so that litigants have assurances that orders must be followed. And there are remedies, harsh remedies, available to the court if the orders are not followed. Today is the date for the show cause hearing. At this time, you've been charged with indirect criminal contempt, ma'am. And I already informed you that you are facing jail time for your failure to comply with 3 of this court's orders. November 16th, 2016, November 30th, 2016, which you agreed to and which was stipulated to, and the June 28th, 2017 order. In all cases of indirect contempt where the alleged act is done outside this court's presence, you are required to receive proper notice of the charges, a reasonable opportunity to prepare a defense, and a hearing on those charges where you have the opportunity to testify and call witnesses. This court has the ability to fine you as much as $7,500 or imprison you for up to 93 days, or both. The court may also place you on probation. In a criminal contempt proceeding, a willful disregard or disobedience of a court order must be clearly and unequivocally shown and must be proven beyond a reasonable doubt. Having been fully informed of the nature of the proceedings as well as the consequences, are you pleading guilty, or would you like to proceed with the hearing? Both parties raise your right hands.
Do you solemnly swear or affirm that the testimony you're about to provide in this matter before this court will be the whole truth and nothing but the truth?
Mr. Vitale.
Yes, Your Honor. I wanted to say first a few things with regard to what the court has stated. Pursuant to precedent in this matter, or contempt in general, she has to have notice, Judge, that she was being held in criminal contempt.
She had notice.
Well, Judge, I'm not aware of any previous statements, aware of any previous documents.
She was informed on the record last Wednesday you weren't present. She had notice.
That this is criminal contempt?
Yes.
Or did the court?
I told her she could go to jail.
Well, a person can go to jail whether it be civil or criminal contempt. Specifically, though, I read the transcript. I don't remember Your Honor saying you're being charged with criminal contempt. She hasn't received any documents stating that. As I read it, the court did not say you're being charged with criminal contempt. The court did say you're being charged with contempt and you face jail time. But I don't remember the words criminal contempt being used. And she's not received anything already. So I have a difference of opinion with Your Honor. I think this is civil contempt as opposed to criminal contempt.
Well, civil contempt is a remedy where we're going to place somebody in jail until they do what the court orders them to do.
That's correct, until they purge themselves of the contempt.
Correct.
And I think that's why we've been here on this contempt, is the order that the court is saying that Ms. Brado did not follow.
I want to make it perfectly clear. We're leaving here today, Dad's picking the child up, and he is going to be vaccinated, regardless of what Mom did or didn't do.
Well,
unless you're going to tell me right now that your client complied with the consent agreement and vaccinated her son. What is she pleading?
Well, again, Your Honor, I think that at this juncture, when the court says the father is leaving with the child and going to have him vaccinated, I think that's a different issue. If that's the order of the court, that's the order of the court. I don't have any...
My point is, there's no point in putting her in jail until she complies, because it will be done regardless of what Mom has done or will do.
The vaccination,
yes.
You say it will be done.
Yes.
That's understood.
Okay. So what is your client pleading?
She's not certain, Your Honor. May we pass the matter so that I can speak with her in the hall?
You may. Thank you.
Thank you.
Okay. Did you bring Casey out? Is anything wrong with Oh, they're right. Oh. Okay. Oh, wait, okay.
All rise. You may be seated.
I'm going to give you your mic back until we're back. Sorry.
I guess after that first one, I probably should have figured that one out. Mm-hmm.
You're in the courtroom this morning and you haven't checked in with me.
I was throwing a Lombard down and looking at it. And the guy had been smart enough to hire a worker for Lombards. You know, so Lombards just bitching at me. And this guy had been drunk down at Cedar Point. I mean, I had it cold. You know, with the kids. I mean, I'd driven and everything. It was really and I said, Judge, I already got a lot of cases. You don't remember them all, but I want to remind you what happened at the last court hearing last of this letter. This guy had written the judge's last. So, you're right, I don't remember what all the... Now I remember you back in chain. He ended up getting the work out. But it was funny because they had got, there was two cases, a PM case and then paternity case, DP or whatever it is. So they had gone down to Las Vegas to sell it. One last night, said, and she got pregnant. Talking about a going away present. So instead of one kid, there was three kids.
How are you? Good. Nice to see you.
John, just have your client send the retainer in. I'm going to give him, I don't know when we'll meet.
Thank you.
I'll give it to you.
All rise.
Be seated, please.
Your Honor, recalling Horn versus Horn, case number 2016 845-891-DM.
Good morning, Your Honor. Stephen Vitale on behalf of Rebecca Brado.
Good morning again, Your Honor. Ben Richardson here on behalf of James Horn, who stands to my right.
I have had an opportunity to speak to Ms. Brado, Your Honor. She will enter a plea guilty to contempt of charge.
All right. Did you want to voir dire your client?
Ms. Brado, you and I have spoken about this.
You were previously sworn. You're still under oath.
We have spoken about this, correct? Yes. Okay.
You have to, could you please?
Yes, sir.
And you have made a decision to enter a plea to the contempt violation, is that correct?
Yes, sir.
Okay. And the nature of that violation is the court had ordered your son vaccinated, correct?
Yes, sir.
And you did not have him vaccinated, is that correct?
No, sir.
Thank you. I don't have anything further.
All right, I just want to clarify that there was a court order stating that he would be vaccinated, but it was also a consent order.
That's correct.
She signed it. She agreed to
I think
it.
I made that clear.
Okay, thank you. And that order was dated November, some 10 months ago, correct?
November the 16th, I believe, was the original order.
And then the
there was
30th.
an order amending that on November the 30th.
Correct. Okay. As to sanctions, Mr. Richardson, do you have an argument to be made?
Your Honor, I'd leave the sentence to the discretion of the court. With regard to the procedural matters, however, I think I would indicate my client tells me that there's been a relatively recent campaign in the home of the defendant to tell the minor child what a bad guy my client is. If he's going to be taking the child now to get vaccinated, we need some extended parenting time so that my client can work that out without being the parent who takes the child out of the home, gets him poked by a doctor, and then has to take him back, which would do nothing but leave fuel to the fire of dad's
Okay, I just want to stop you for a moment and go back here. Your client's pleading guilty. I do want to state her to state on the record. Was the child vaccinated in the last 7 days?
No, ma'am.
No, you did not do that.
No, ma'am.
Okay. Mr. Richardson, as to parenting time, I'll hear that later. In terms of sanctions, you need to take a position. You filed a show cause order and you asked for jail time. What is your your position today?
Well, Judge, I think that's the only thing that's going to get the attention. In fact, Ms. Brado has made very clear that she would rather sit in jail than get the child vaccinated and follow the court's order. So I think that an imposition of jail time in this case is necessary in order to make it very clear that when you said it last week, when you said it in November, when you said it again in November, and when you said it since then by your orders, she's decided that she doesn't need to follow those orders. And I think the only thing that's going to get her attention is for the court to follow through on the statement that we made last week that says that she's going to go to jail if she doesn't comply. She clearly hasn't complied. Instead, she went out and she told everybody who would listen that she's going to go to jail instead. So I'm in a position where I think that that's what needs to be done today. She needs to be sanctioned with some sort of a jail sentence. I would think something in the range of at least 3 weeks in order to give my client time to be with the child, to make the arrangements that are necessary to get the vaccinations caught up would be a minimum. I understand that the court has the leeway to go much higher than that. This is the first time that she's been found in criminal contempt, and I hope that it'll be the last. I hope that this will get the message through from this court that this isn't about the vaccinations. This is about your orders being followed and the consent orders being followed in this case. So that's basically the position that we take in this matter.
Your Honor, my position is that Ms. Brado should not be incarcerated. In fact, I don't even think it's permissible to incarcerate her. I'll cite the court to MCL 600.1715, paragraph 2. States quite clearly, if the contempt consists of an omission to perform some act or duty that is still within the power of the person to perform, the imprisonment shall be terminated when the person performs that act or duty.
That's civil contempt.
Or no longer has the power to perform the act or duty which shall be specified in the order of
That's civil contempt.
That statute, Your Honor, applies to both contempt in general before.
You're not reading the entire criminal contempt statute. It does provide for sanctions, $7,500 fine, and or 93 days
What
in jail.
statute is Your Honor referring to in that regard?
Mr. Vitale, you want me to cite the criminal contempt statute?
MCL 600.1715 is what you're referring to.
I have the ability under the statute to, we already discussed this, 93 days in jail if somebody doesn't comply with a court order.
In certain circumstances, yes, Judge. I believe when you look at the statute, which I think the proper statute pursuant to all case law throughout Michigan is 600.1715, if it is this type of contempt, i.e. not complying with a court order, once she no longer has the power to do that, if the court enters an order like Your Honor alluded to earlier, child's leaving with dad today, there's going to be an order for the father to vaccinate him. As soon as that happens, it's no longer her duty to vaccinate the child. As soon as it's no longer her duty, the contempt is considered by operation of law under paragraph 2 to be purged. Therefore, she can't do it anymore, and the statute's quite clear that if that happens, then imprisonment must cease immediately.
I disagree. Under 600.17151, the court has contempt powers, and
don't dispute
they
that,
have
Your Honor.
contempt powers. The court has contempt powers to compel somebody to do something, but they also have contempt powers to punish somebody for not complying with an order.
But whatever the act that constitutes the consent is essential, Your Honor, because
We're going to disagree on this. You've been heard.
Ms. Breed, I would also like to make a statement first.
Okay, go ahead.
Your Honor, I would like to offer my most humble apology for having to stand in front of you today. I take full responsibility for my actions, and it was not my intent to disrespect Your Honor or to disobey the court's orders. I stand here today scared and vulnerable, begging the court to understand that I'm not a lazy parent. I am a passionate mother who cares deeply about my children, their health, and their well-being. This order has taken on a life of its own, Your Honor, and it is my fault that I have not stood up sooner and explained to the court that I am an educated, vaccine choice mother, and I have signed vaccine waivers and have been fully compliant with all state Michigan laws for both of my children for every school year. And if my child is going to be forced to be vaccinated, I couldn't bring myself to do it. It goes against my beliefs, Your Honor. My marriage to Mr. Horn was annulled over 9 years ago, and we've always shared the same beliefs on vaccinations until recently. I beg the court to see that Mr. Horn's newfound belief on vaccinations is nothing more than his leverage for him and his attorney. Your Honor, on November 16, 2016, in a motion I was never served notice of, and after reading the transcripts from that day, it is very clear that Mr. Richardson took the liberty of writing that all vaccinations be brought up to date. As it shows on the record, Your Honor referred all matters to the FOC for an
Okay,
evidentiary
ma'am, I'm
hearing.
going to stop you because the truth matters to me. November 30th, you appeared to set that order aside. You never went before me. You agreed in a consent order to vaccinate your child. 1. 2, I understand you love your children, but what I don't think you understand is that your son has 2 parents and dad gets a say. And the record, I urge you to review it, and anyone else. What you just said, that he has a newfound objection, is not true. You acknowledge in your own pleadings your child at a year old was up to date on all his vaccinations. You acknowledge that in your own pleadings. I'm not going to take time today to listen to the facts as you see them. I just urge you to really read the record, because I have, and what you're saying is just not true. Contempt is a serious and critical power the court has. It's available to the court so it can enforce orders and so that the people before me have confidence that an order means something, and I don't take it lightly. It's clear to me that you don't care about orders, even if you agree to them, which you did. You agreed in November 30th. Your attorney signed that order. I reviewed your testimony at the FOC hearing where you acknowledged that you enrolled the minor child in a different school without dad's consent. You've admitted in this court previously that you unilaterally changed the child's therapist without the court's approval or dad's consent. You signed a waiver for vaccinations without dad's consent. And you've repeatedly stated over the past several days publicly that you will not follow this court order. So I'm sentencing you to 7 days in jail. And I also award Dad temporary physical custody while you are incarcerated and until enough time has passed for him to bring your son's vaccinations up to date as rapidly as medically necessary, which is the language in the order. Father, you are to set up that immediately when you leave here and also pick up the minor child at school. He is with you. We will set this matter for a review a week from today so that I can have the status and the report on the vaccinations. Thank you.
Your Honor, may I speak?
No, I'm done here.
Again, I'll make the same objection, Your Honor.
Mr. Vitale, we are done here. Call the next case.
Your Honor, now calling docket number 52, Hoffman versus Hoffman. Case number 2017-856-491-DO.
Good morning. My name is Janelle Velarde. I'm appearing this morning